and they're not worried when they're grieving. So personally, when my dad passed away, we had no clue what to do with his remains. Everything was just like all over the place. I remember when he passed away, they asked me for his eyes, and I thought it was insensitive because I'm grieving. And then when I made the decision that I did want to donate his eyes, it was too late. But had I known in advance what my dad wanted to do, then I would not have to have made those decisions on my own. And so we want to make sure that the people that we love don't have to worry about going through a bunch of court systems and having to figure out things on their own while they're grieving and you're in transition. People also get sick, and when you get sick, other people need to know what to do. So you need a health proxy. There's a lot of different things we need to do to make sure that if something happens to us, that the people around us know what to do. And while I know that some may think this is for older people, people with assets, everyone who is able to make a decision for their life should have something in writing to say what's next. My daughter's 23, and I even had to have the very uncomfortable conversation with a 23-year-old about like what does she want to do with her money, finances, her body, and all those things when she's no longer here, if God willing. So I want to say thank you for being here, and I'm going to hand it over to Kenneth and Hanzel.
Thank you, thank you. Thank you to the Jackson team for having us and allowing us to share this information with you. A little bit about myself. My name is Kenneth Mungin, and I'm a real estate broker. I have an office in New Hyde Park, and I also have an office in the Bronx, 3942 East Tremont. So the information that we're going to share with you guys today is very, very important. Not only have I personally been through this, like Miss Jackson with my father-in-law when he passed in 2012, it was a lot. People don't really realize what they have to go through, and that's why it's so important to try to prepare the best you can and have the information. Because if I would have had some of this information that I had years ago, it could have saved me a lot of stress, time, money, just a lot. Um, a lot of people don't realize, unfortunately, that, things do happen and bad things do happen. And the people that do prepare are the ones that usually help just focus on just mourning the person, not having dealing with all the crazy things that come with it. So my goal today is to talk about wills and trusts with everyone. The way I'm going to do it is I'm going to talk about what a will is. I'm going to give the breakdown of how it's set up. I'm going to talk about the pros and cons of it, and then I'm going to talk about a trust. I'm going to talk about what it's for, how it's broken down, and I'm going to talk about the pros and cons of that and do a side-by-side comparison. After that, I'm going to pass it over to the attorney Hanzel, who's going to talk a little about the probate process and what he sees going on every day with people in his practice that don't have wills and trusts and don't prepare. So I have a lot of information I want to cover with you guys, so I'm going to get right into it. Let me just get the thing going. So if anyone wants to take any information on me, that's my QR code. You can take your phone and scan it real quick. That'll give you directly to my Instagram. A lot of people can reach out to me directly through there if they have any questions or if they have any things like as far as wills and
Kenneth, give
trust.
me 1 second. To my
Sure.
team who's running the back office, can you please mute the person on the cell phone?
Thank you. So again, you can scan that. It'll take you to my Instagram. If anyone ever has any questions or would like to reach out, I'm very responsive. They can reach out anytime. And then we have Hansel's information right here. He's an attorney that I've worked with for a long time. He's very good at what he does. He's very good with people. He's very compassionate. So if you like to scan his QR code, it'll take you right to his Instagram and if you have any other information. Okay. So we're going to get right into it. So what is a will, everyone? So is a will or a last will and testament is a legal document that describes how you would like your property and other assets to be distributed after your death. When you make a will, you can also use it to nominate guardians for your children, dependents, or pets. So a lot of people, a lot of times will ask me, Kenny, when should I make a will? Should I have a will? And the general rule of thumb is if you have assets over $50,000, you should really have a will. And it's not always necessarily property. You can have jewelry, you can have bank accounts, you can have certain assets that are very personal to you. And if it's over 50,000, you usually want to have a will. If it's under 50,000, you don't necessarily have to probate it, which we'll go into what that is later. But usually everyone should have a will. And just for numbers, only 33% of Americans actually have a will. So if you think about that, that's very, very low number, and a lot of people own assets. So most people on this call probably do not have a will. And if they do, they probably know somebody that should have a will or doesn't have it. So it's very, very important. So the way a will is structured is you have what's called the testator. Okay. So for instance, if I was opening up a will, I would be the testator. This is the person that creates a will. Okay. Now, once you create your will, you're going to have to do something very important, and you're going to have to select someone who's called the executor. The executor is the person that the testator appoints to carry out their will. Now, this is very important because the person you select, it can be, a wife, it could be a child, it can even be an attorney, it can be an uncle, it could be a friend. You want to pick someone that is very trustworthy and that's going to handle your final expenses after you're gone. So you just don't want to pick anyone. So this is why when you're starting to create a will, you have to really think this through and who you're going to select, especially if you have multiple children. You probably want to select the child that you feel like is, most responsible, because it is a lot of work once unfortunately a person passes, because you basically have to step in that person's shoes to fill the whole process. Okay. So once you select your executor, then you have to select what's called your beneficiaries. You probably heard this word before. If you ever had a bank account or life insurance, you have to pick the beneficiary. The beneficiaries, the people or organizations who are left cash gifts or other assets in the will by the testator. So you can also leave your assets to like a pet, a charity, the church. This is why it's very important to have a will, because sometimes, people, especially that you have gained assets through your lifetime, you want to know where those assets are going when you're no longer here. And if you don't have a will in place, then the state will select an administrator, and sometimes that might not be the person that you want. Okay. So once you have your will in place and God forbid something were to happen to you, you're going to go through a process called probate. Okay. Now, probate is the judicial process whereby a will is proved in a court of law and accepted as a valid public document that is true last testament of the deceased, or whereby the estate is settled according to the laws in the state of residence of the deceased at the time of death in the absence of a legal will. Now, every state has slightly different rules when it comes to wills. So, for instance, like in New York, you need to have two witnesses, and you should have it also what is that called? Notarized. And you should also have that stored in a very safe place, because when you do have to go through probate, you do have to have an original copy. If you don't have the original copy, that could be a problem, which I personally had to go through and find it. So you have to go through the probate process, and the probate process, it can be lengthy. It takes on average anywhere from 1 years. It can go as long as 6 to 10 years. My personal experience, when my mom's husband died, he had seven brothers and sisters. We had to go through the whole probate process, and that took 6 years. So this is why you want to select an executor that can take the time to go through this process, because depending how big your estate is, this can take some time. So some of the pros and cons of establishing a will. One is estate distribution, right? So if you have multiple assets, you want to figure out exactly how you want those assets distributed. Let's say you might want to leave $50,000 to your daughter, you want to leave $10,000 to your son, you want to leave the house to an aunt. You want to have how those assets are distributed, whereas if the state selects an administrator, you might not have a selection on how that goes. So it's very, very important. That's a big pro why people get wills in the first place. Second thing is executor selection. You get to select the person who steps in your shoes if you're no longer here. And in my mom's situation, James, he had seven brothers and sisters, and he didn't really have great relationships with them. So he actually selected me as the executor because he knew I would be able to do everything, God forbid something happened to him. And something unfortunately did, and thank God, because it was a lot of work and I had to actually lay out a lot of money in the beginning to do everything. So that's a big pro. Second thing is it's cost effective. So when you're comparing wills and trust, wills, technically you can do it by yourself as little as $50 to $100 if you can use things like LegalZoom and stuff. I don't always necessarily suggest that, depending on how much experience you have. But usually I've seen it be anywhere from $300 to $800, depending on the attorney you work with and stuff like that. So it's not super, super expensive. That's why you should really set it up, because if you don't have it in place, it can cost you thousands and thousands of dollars afterwards. Some of the cons of a will, it's public record, and we're going to talk about trust in a second. Well, when you have a will, if you have assets, those assets are open to the public. So a lot of times people, want to hide their assets and they don't really want people knowing what they're own. So for instance, I'm a realtor. If I look up a person's name or look up a property, a lot of times it'll show me who that owner is. So you can't really hide it with the will. Number two is the probate process. The probate process can be very lengthy. It can be very time consuming. And if you hire an attorney, the average attorney charges anywhere from $250 now to $500 an hour. So, which we will learn shortly with the trust, you can actually skip the whole probate process. So that's another kind of con when it comes to when you're comparing wills to trusts. Okay. Second thing is lack of control. So when you pass away, you can just figure out how you want your assets distributed. However, you'll hear the terms like you ever heard of like the term trust fund baby and stuff like that. Sometimes you have certain assets like businesses and other things that you want to pass on, but you want to dictate how you want those businesses and assets to be distributed over the long term, which is very hard to do during a will. So you don't have as much control as you would do with a trust. Second thing, another thing is no incapacity planning. God forbid let's say you're in a car accident, you're in a coma. You can't touch the assets, you can't do anything until you actually pass. That's when the will actually takes effect. So a lot of times, if you have a will and you have multiple assets, that's why a lot of people start with the will and then they might move to the trust because you'll see later with the trust, if something were to happen to me and I didn't pass away, the next person in line can just step in and do what they have to do. Okay. This is a big one, potential for challenges. You'll see this a lot, especially with celebrities or people that have big estates. So let's say someone passes away, and what happens is you have to file a petition and everything's sent out to everyone, letting them know that someone passed and this is the will. Well, there's plenty of times where family members will see that or other people and not agree with it, and they'll contest it, which means they'll hire an attorney and try to contest the will in a court. And that could be very time consuming. It can cost a lot of money. And it happens all the time. I'm dealing with a case right now where a father passed away. There's three children. It's a house in Brooklyn. The house is worth quite a bit of money. And one of the children feels like they should get the house entirely because they live there and the other two siblings shouldn't. So he contested the will. He hired an attorney. They're going back and forth, and the attorney fees are getting higher and higher. And I don't know what's going to happen by the time we actually sell the property. There's probably not going to be much left of the proceeds to go to the children. So that's a big thing too, with people potentially challenging it. And the last thing is there's no real tax benefits. So what we're going to learn shortly with the trust, a lot of people, when they pass, they can have things in a trust that will give you certain tax benefits where you can defer the taxes. You ever heard of the things called trust fund babies, where maybe the grandmother puts money in a trust for their child, and then they dictate when that money is distributed to the child. So there's a lot of different tax advantages when it comes to trust, which I'll go over. But that's a case by case scenario. So a lot of times what I tell people is you want to sit down with a professional. They'll look over your assets. They'll look at your entire financial picture and point you in the right direction. Okay. So that being said, what is a trust? A trust is a legal arrangement that allows individuals to transfer assets across generations while creating guidelines over how and when those assets are distributed. Trust can offer benefits like privacy, asset protection, and flexible wealth transfer options. In other words, trusts give you a safe way to pass your wealth to your family members while also potentially providing tax benefits. We will go over a typical trust structure and compare various types of trust before providing insight into how to start the process of trust planning
I'm
and how
sorry,
a family
Kenneth.
office can support
I'm so
you.
sorry. Can someone please? Oh, they're muted.
Yeah, we're good. So what a trust is, first of all, when you set up a trust, you're going to have the person that sets up, which is called the grantor, okay? Sometimes called the truster or settler. The grantor establishes the trust and places assets into it. So guys, I want you to think of it like this. Let's say I was opening up a trust. You want to think about it, it's like you're opening up like a holding company, okay? So let's say I have my house under my name. What I am doing is I'm opening up the trust, and then I'm taking my property out of my name and then putting it in the name of the trust. Okay. So it's a way of getting assets out of my name, and we'll go over the other things we have to select. So once I open up the trust, we call funding the trust. We have to put the assets in the trust. I also have to select what's called the trustee. And whether there is one trustee or multiple, the roles managing the trust according to terms outlined by the grantor in the trust agreement. Trustees are held to a fiduciary standard, meaning they are required to act in the best interest of all beneficiaries. Trustees have several key responsibilities, all pertaining to the management and administration of the trust. So even as the grantor, I can select myself as the trustee. So think about it this way, like I have the company, I put the assets in the company, and I'm like the CEO. But then what I can also do is select the people under me who are the trustees. So let's say something were to happen to me, the next person in line would step in place and it would kind of be like business as usual. What's also nice about trust, you can set what parameters each trustee has. So for instance, if you want one trustee to be able to do more things than the other, you have more control of that and you can set that within the trust, which is really, really nice. And just like the will, you have to select your beneficiaries, right? Now, this can be one or multiple beneficiaries who receive principal and or income from the trust. While a beneficiary may also serve as a trustee, which we'll cover next, they will still be required to adhere to the fiduciary duty to act in the best interest of the beneficiaries and not just themselves. Okay. So when you go into the trust structure, it looks something like this. You are the grantor. Okay, and then you select your trustees, which if you're the grantor, a lot of times you're going to make yourself one of the trustees. Now, if you notice, the grantor is on top because they're the one that selects the rules. They select how everything's going to be managed within the trust, and it's the trustees' jobs to carry this out. Now, the beneficiaries can also be the trustee, and there could be multiple beneficiaries. But what's very important, if you have, let's say, one trustee and five beneficiaries, or let's say I select my son and I have other kids that are going to be beneficiaries of the trustee still has to work in the best interest of all the beneficiaries. That's why it's very important that the person you select for this is very trustworthy and it's someone that you feel like can handle this, okay? Now, there's going to be two types of trust that you usually come across, okay? There's going to be two broad categories. There's going to be what's called revocable and irrevocable. Each type has benefits, with the main difference being the level of control the grantor retains once the trust is established. Okay. So with a revocable trust, this is what most people are going to get, and this is what I have currently right now. What I like about it, it can be altered or terminated at any point during the grantor's life. So a big question I'll get a lot of times, like, hey, Kenny, I have a house. I want to put it in the trust, but let's say I want to do a HELOC or refinance. Am I able to do that? The question to that is yes. However, what you would have to do a lot of times is take the property out of the trust, put it back in your name, do the refinance or the HELOC, and then you can take it and put it back in the trust. You can also open up multiple types of trusts. You can have different trusts. You can have a trust for your house. You can have a trust for your business. That's when you want to sit down with an attorney to figure out what the proper structure is for you. But what's nice about revocable trust, you can constantly change things. And that's what's nice about it. It's not set forever. Now, an irrevocable trust, this is where you have to use an attorney. You cannot do this without an attorney. And this cannot be altered or terminated once it has been established without complying with modification or decanting requirements. So a lot of times you're going to see these type of trusts when there's big estates or there's a business involved and there's multiple properties, or you want distribution set a certain way. I'll give you an example. Let's say you have a child and you have a big estate and you only want that money given to the child when they turn, let's say, 18, 25, 30. You have more room to do that, and it can be set up through an irrevocable trust. There's also other things you can do for tax deferring issues, which is really, really nice. And that's, again, you have to sit down with an attorney to figure out what assets you have to pick the right proper trust. Okay. So these are some of the pros and cons of establishing a trust. First thing is big is asset protection. And I'll tell you a little story that happened with myself. So 2 years ago, my wife got into a car accident. Thank God, she's okay, everything's fine. But what I didn't realize is that sometimes when accidents happen, attorneys, they do title searches on people. And if they see you have assets, sometimes they will sue for more than what the insurance pays out. So one big thing with asset protection that I like is that when I take the property out of my name and put it in a trust, I no longer own that property. It's owned by the trust. So if something were to happen with me where I'm personally getting sued, that asset may not be at risk. Now, it might be different when it comes to the IRS and different things, but for the most part, that's what a lot of people like is the asset protection. This is why if you ever meet a person or you hear people talking saying, oh, I don't own anything, but they seem like they're worth a lot of money, is because they own their assets in trusts. Okay. Second big pro is control. Unlike the will, you only can really distribute your assets after you pass. With a trust, you can have more control from the grave. So, for instance, I have a family member who owns assets in South Carolina, and he doesn't want certain family members being able to freely sell the assets and do certain things. So, within his trust, he outlines certain guidelines of what can and can't be done with the properties, which is really, really nice, especially if you're trying to protect your legacy and maybe you're leaving it to people that might not be able to manage it correctly. So you have more control over that. Another big thing is privacy. So, for instance, if anyone here has ever owned property, as you know, because I do it myself, you're going to get many, many calls from realtors and people asking you questions. Do you want to sell? Because a lot of that information is visible. When you put your property into a trust, like with mine, it's kind of hard to see because it's like my thing is the property address trust. It's much harder to find who the owner is. So I personally like it because, I like to be private with what I own. And you'll see a lot of people. This is why if you ever try to look up certain celebrities or try to look up where they live or look up their assets, it's very hard to find because a lot of them put their assets in trust. So it's not easily visible and they want to keep that private. And another big thing is tax efficiency. So a lot of people that own homes in New York, as you know, the homes went up a lot in value. And when you pass, there's certain tax obligations that can kick in, especially estate taxes. So with trust, there's certain things you can do where you can put it in and you can avoid certain taxes or not necessarily avoid, but you can defer them. So what you can do is, let's say you have a trust where you're paying out a certain amount of money every year, you can set those guidelines so you don't trigger certain tax events. Okay, so that's a big thing that I work with a lot of clients, especially that have a lot of money. A lot of them, we do a lot of tax planning around trust and setting it up so they're not getting killed in taxes when they pass. Because people don't realize after over, I believe, 7.5 million, the estate taxes kick in and it could eat up as much as 60% of your assets when you pass it on. So it's a big thing that I tell people because as you own property, these properties go up and up in value, and the government was nothing more than to tax you. So some of the cons is the cost. So the average cost of a trust I've seen on average could be between $3,000 to as high as 6,000 or more, depending on the complexity of it. It then does tend to be a little bit more. As far as how many people actually have a trust, only 17% of the population actually have a trust. So if a trust doesn't necessarily seem right for you, I definitely suggest getting the will. And as you get more assets or depending on your situation, then move over to a trust, but the will is the minimum thing you need to get. And then the complexity. Trusts are not really easy to do. I'm pretty good with paperwork and all that stuff, but even me, I got an attorney to help me do this, especially when it comes to funding the trust. And if you're putting businesses and properties in it, especially if it's in different states, a lot of times I suggest you using the help of an attorney because it can be very, very complex. So these are some of the big differences between a will and trust, so we can put a side-by-side comparison. So for instance, with the will, probate is required. Like I said, probate, Hansel's going to go a little bit into probate a little bit. It can be anywhere from a year to 2 years. Sometimes, depending on the complexity of the will, it could take up to 6, like my situation. Where the trust, there is no probate, which is great. I mean, if I would have known this back in 2012, I would have told my father-in-law to put his assets in a trust, and we would have never had to go through the probate process. The probate process in total ended up costing me $15,000. So I would have happily paid $3,000 for the trust back then. Second thing is your assets are public. In a will, where in a trust, your assets are private. You can hide them. It isn't as visible. You don't, as you gain wealth, you don't want people knowing what you owe. Wills do take less time to create. As we're a trust, it does take more time. So that's why I tell a lot of people the minimum thing you should do right now is at least get your wills in place because, things unfortunately do happen. No one expected COVID in 2020, and I can't tell you how many clients I dealt with where they passed away, where parents passed away, and the kids don't know what to do, and they had nothing in place because unfortunately, when these things happen, no one's really prepared. I never really met a person that said, "Oh, I was prepared for this person to die." When it happens, it usually happens when they least expect it. Okay. As a will, it only takes effect upon death. Where trust, they have certain things where what is called incapacity management. So let's say, God forbid, I get into a car accident, I'm on a breathing tube, or I'm brain dead. The next person in line can step in and handle the business, still have access to my accounts, and still do things like business as usual. So so they're not frozen out of everything, especially if there's a business involved. Okay. A probate can take up to 1 to 2 years to do, depending on the state. I see New York, that's usually the range it does. Where a trust, if God forbid something happens, it only takes days to update. So that's a very big positive because, for instance, in my situation, when my father-in-law passed away, he had certain bank accounts that my mom was not listed as a beneficiary on. So I had to lay out a lot of the money ahead of time before we can get the money back, and that was, a financial strain at the time. Wills do cost less to draft. Like I said before, wills, can cost anywhere on average from $200 to $800, while trusts tend to cost $3,000 and up. So that is a big difference when you are thinking about which one you want to do. Wills tend to be a lot less expensive. Wills are more costly to the administrator, and what that means is that the executor, that once someone passes away, a lot of times the executor is handling a lot of these finances and they do get that money back, but in the beginning sometimes they are laying out a lot of that money up front. So that's why the executor you pick, you want to pick someone that is also pretty much financially responsible, because when someone passes away you don't really pass away. It's just your executor now stepping in your shoes, and they have to do things like file your final tax returns, they have to pay off all your creditors. There's a couple of things that have to be done before all the assets can finally be passed on. So it can be very costly to the administrator. And I see this a lot when people pass away. Who's going to pay the funeral costs? You know what I mean? That happens a lot. Whereas with the trust, like I said, the next person, the trustee, the next person steps up and they can handle things as business as usual because they'll have access to the bank accounts and what other assets that are put in the trust. Okay. And like I said, with wills, the assets are frozen upon death. So you're going to have to probate the will. You're going to have to get letters of testament. Testament. I always say that a little wrong. And then you can actually get access to the bank accounts and their assets. And it can be very, very time consuming. It took me about a year and a half to get access to everything. And during that whole time, I had to still pay his bills and pay everything like if he was here, because if I didn't pay his bills, he was going to incur all these charges and stuff. So it's very important. Whereas with the trust, none of the assets are frozen upon death, which is a big plus. And the last thing that I like to say is that wills are very easy to contest, whereas a trust, they're non-contestable. So I was very lucky in the situation where, the seven brothers and sisters, they didn't contest anything. They understood everything that's going on. But in a lot of cases, people contest the will all the time. And once you start getting attorneys involved, like I said, it becomes very, very expensive, time consuming. And I see families literally get destroyed over this stuff because people are fighting over who should get what. This person didn't leave me this. And it just turns into a horror show. Whereas with the trust, they are non-contestable, which is another big reason why I wish I knew about this then. But now I do have a trust. Okay. So there's many different types of trust, and I'll just kind of run through a couple. So you have like marital trust, bypass trust, spousal lifetime access trust, charitable trust. There are so many different types, and this is why, and a lot of these are irrevocable. This is why a lot of times you want to sit down with an attorney. And depending on your situation, you can reach out to Hanzel, you can reach out to me, and I'll push you in the right direction on who to talk to. Because this is what I see a lot of people, especially wealthy people. And you don't have to be wealthy to do this, by the way. They put these trusts in place so that the next generation is not losing out on the assets. They even have things called Medicaid trusts. So there's ways you can put your assets in a trust, and there's something called the 5-year look back period, depending on which state you're in and stuff, where then you could still qualify for things like Medicaid and stuff. So there's a lot of different types of trust. There's a lot of options people have, but this is why I wanted to share this information with everyone and give you kind of a general understanding on how trust and wills work, so that you can reach out to either myself or Hanzo, and we can help you guys out and point you in the right direction. I appreciate you guys taking out time, spending time with me, and I'm going to pass it over to the attorney, Hanzo. Thank you guys and have a good night.
Thank you, Kenny. Can anyone hear me?
Yep, we can hear you.
Okay, great, great. So, just a little bit about myself. And thank you, Kenny, for that. That was awesome, right on the point. So I graduated from Toro Law in 2020, and I passed the bar same year. So I've been practicing for about 6 years. Um, I work with Kenny all the time. Kenny's very knowledgeable, as you can see. Um, just a little bit about the probate process. I specialize in real estate, and I see this happen a lot of times because when someone passes away, usually someone owns a home, and a lot of people, they don't know what to do with the home once someone passes away. Um, the probate process could be a little lengthy. Typically, it takes about, from my experience, 6 months to 18 months, give or take. Probate is basically um, the process of proving that the will is valid, right? Now, when someone doesn't have a will, it's someone needs to be named the administrator. It's the court needs to appoint someone to administer the assets for the estate. And when you do have a will, um, someone gets named the executor, right, through the will, and they manage the assets. So what I always recommend to people is, especially when you have assets, you definitely want to have a will, because, like I said, from my experience, I've seen situations where someone passes away without a will, and you have to go to surrogate's court, and you have to petition to the court someone to be named the administrator of the estate. And as Kenny pointed out, a lot of times people contest certain things. So the probate process, I mean, it could be expensive as well. Like Kenny said, it could be lengthy. So if you're looking at 18 months, um, you're paying a lot of legal fees in that. Um, Let me see. Just look at my notes here. Um, yeah. Okay, so just the process of probate, right? So I want to talk a little bit about the process. So let's say someone does have a will. The first step is you have to locate the will, right? You have to locate the will, and this is very important. You learned this in law school. Whenever you have a will, the staples. It sounds kind of silly. The staples in the will cannot be removed. You can't remove the staples from a will. Once a will is created and they staple it, you can't remove it. If the staples are removed, the court interprets that as the the person the deceased didn't want the will to be executed. So it's very important that you don't remove the staples from a will. Okay. So the first step is you locate the will, right? The second step is you file a petition for the probate, right? So you submit the original will, the death certificate, names and addresses of the heirs, the beneficiaries, and you submit that to probate, to surrogate's court. Um, let's see here. The third step is you notify all interested parties. Like I stated before, the heirs are the interested parties. They are the people standing to be the beneficiaries of all the assets of the estate. Okay, so here. Oh, step four, you have to prove the will's validity, right? So when you would provide witnesses, affidavits, some people might even testify. You have to prove that the will is actually valid. So that would be the fourth step in the whole probate process. Another step would be you have to appoint the executor. So the court issues something called letters of testamentary. This is when someone has a will, right? When someone has a will, the court appoints the executor to the estate. When someone doesn't have a will, it's called letters of administration. Someone gets appointed to administer the assets to the estate. So that's the difference between having a will and not having a will when someone passes away. Another step is the executor gathers and lists all the assets, meaning like real estate, bank accounts, investments, personal property. Um, you might even it might even require professional appraisals for like a home or something like that. So that would be another step for the executor. Another step is you have to pay off all the creditors, right? So just because someone passes away doesn't mean they don't have to pay off all of their debts. So any debts owed, they have to get paid before you could administer the assets. So funeral, any creditors or taxes that might be owed by the deceased, they get paid first, and then you have to administer the assets after. And the last step would be to close the estate. The executor prepares final accounting. The beneficiaries sign the receipts and release forms. The court reviews and formally closes the estate. That is typically the process, the probate process in surrogate's court. Not sure if anyone had any questions regarding that.
There's lots of questions. My staff
Okay.
is going to go through them.
Yes,
Okay.
so we
Okay.
do have a couple of questions.
Okay.
Let me just scroll to the top. I don't want to miss anyone.
And thank you again to Kenny and Hanzel for putting this together. All right, Chris, you ready?
Yes. All right, Am, did you get the answer to your question?
Yeah. Are you looking
Okay.
at the document?
Yes, ma'am.
Okay.
Okay, so the first question is, will the participants receive copies of the slides?
Yeah, I
Well,
can send copies of the slides. That's not a problem.
and this is being recorded on our YouTube, so you can always go there, which you will receive actually in an email at the end.
Okay, so the question is, what about individuals, beneficiaries that have guardianship and someone oversees their decision making? How does a trust protect them and their assets?
I'm
Say that
sorry.
again.
Can you repeat that?
It says, what about individuals, beneficiaries that have guardianship and someone oversees their decision? How does a trust protect them and their assets?
I mean, I believe it's a little so you can create a trust and you can select who like who the guardianship is and stuff like that, but it would be dictated within the trust. So what you would want to do is sit down with an attorney, go over exactly what you want done, and then they would put that within the trust. But you can also select that through the will, who the guardianship is going to be. So for instance, also in a will, you can select your who the guardian was if something were to happen to you.
Yeah. So just to piggyback off what Kenny
Yeah.
said, so the trust dictates, how the guardianship would, take care of the beneficiary. I'm not sure if that's exactly what their question was.
The next question is, what if the last beneficiary is aging and ongoing to pass and the trustees have also passed and the grantor has passed?
So if they all pass away
Yeah,
and there's no next of kin or anything like that.
correct.
No, I think
To the
they're saying
state
like
then.
everyone that was on the trust
Okay.
is gone. I think that's what they're saying.
But I mean, if you have relatives, um, I believe that the court would just, you know, there's there's a whole intestate chart, right? So if someone passes away and there's no one left in the trust, then it would possibly pass over to the family.
Okay, the next question is, what if the trustees are not fulfilling the terms of the trust?
So the grantor can remove them. So remember, the grantor is always in control of the trust. So they select the trustees. So if they feel like the trustee's not doing what they need to do, they can remove them and change it around. And if you are a trustee, you have a fiduciary duty to all the beneficiaries. So if you're not doing what you need to do, it could be a big problem, legal problem. So that's why it's very important that I show that the beneficiaries and trustees are on the same level. So if there is an issue where the trustee is not doing what they need to do, the grantor can remove them.
Thank you, Kenneth. The next question is, if someone is left a trust, does that necessarily mean that they're not in the will?
You can
No.
have a trust and not have a will. You can have a will and not have a trust.
Mhm.
So it really depends on how it's dictated. You know what I mean? So and the same thing, like you were saying, Hanzo, if someone passes away, you don't have neither, then they'll appoint an administrator and then they'll figure out how it's distributed. This is why you want one or the other, because you don't want the state to appoint or the courts appointing whoever's going to be doing it.
Thank you, Kenneth. Can people contest a will even if they are not listed in the will?
Yeah. Yeah.
It happens all the time, especially
Yeah.
when people get divorced and stuff like that. You have ex people come out of the woodworks.
Mhm.
You have cousins, you have family members that say, "Hey, I own that," or "I was promised this." It happens all the time.
That's usually the reason why, is because they're contesting because they're not in the way.
Thank you. Are there any more questions?
So to avoid people contesting a will, is it better to just get the trust?
Well,
Yes, in a
in
sense,
that
yeah.
sense, yes. In that sense, yes. Um, you know, like Kenny said, people contested so many times. Um, in that sense, you do want to trust because you have more control, right? You have more control, and no one's contesting a trust. But there are, like Kenny pointed out, there are pros and cons to either or.
If someone needs they have personal questions, because you guys cannot advise on this
Mm.
call, people should personally do. Who should they reach out to for those questions to
I
be
mean,
answered?
either one of us, me or Kenny. What we like to do is Kenny and I, we like to work as a tandem, so either or, and then you know,
Yeah, and
yeah.
depending on the question, what a lot of times I do, I work with a lot of different people. So if it's something that's outside of our scope, I have a very extensive network. So I point people in the right direction. So usually what I do is I gain all the information, I figure out what the client's trying to accomplish, and then I point them in the right direction. Because like for instance, if they're doing something where it's like a couple of businesses and it's like a really, really big trust that we have to put together. Hanzo also works with a team of attorneys that more focused in that and will get
Mhm.
connected with those people. So it really depends on the client, what they're looking for. But I have a lot of connections. Hanzo has a lot of connections. And what we do is we get the information and we just point them in the right direction.
Okay. And what if sorry, I just lost what I was thinking. I just lost my thought. Oh,
But
when people with younger children, what should they do in preparation for them? What can
For
they do?
them,
Yeah.
yeah, no problem. So for me, like I did with my will, there's a section with the guardianship. So that's very, very important. So for like my son, I selected who the guardians are in case something were to happen to both me and my wife. Now, if there's money involved, that's when you probably want to trust. So, for instance, I'm actually working on my trust now for my son because God forbid something happens to me, I don't want him getting all that money at 18 years old because he's going to blow through it and spend it. So, what I'm going to do is set up a trust where it's going to give him a certain amount of assets as he hits certain stages of his life. So this way, he's not getting all those assets at one time. So you can build trust around that, but if you don't have a trust, you can name it in your will who the guardian would be, God forbid something were to happen to you and your spouse. So that can be set up in a will as well.
And what if something happens to the children?
Then what with the children and the spouse, like everyone?
Well, no, I'm saying like, what if something happens to the children? Do the parents just decide what happens?
Well, usually, like, let's say something were to happen to me and then something happens to the children, then it goes to your heir, the
Your
next.
heirs, the
Yeah,
family.
that's
Yeah.
usually how it goes. Yeah. So the assets don't go just nowhere. It goes to the heirs. Now, if there are no heirs, then I believe, if I'm correct, Hanzo, goes to the state, correct?
Yeah, yeah, exactly. So like when the first question someone asked, what happens if, the grantors pass away, the beneficiaries pass away, it goes to the heirs. And if there's no heirs, then unfortunately, I don't want to say unfortunately, but it just goes to the state.
Well, we don't want that. Um, are there any other questions?
Yes, I put a question in the chat.
Mhm.
Is it necessary to have both a will and a trust?
N- Well, I mean, I would always advise someone to have a will and or a trust, but it's not obligated if that's the case. You're not required to.
It
I
depends
would.
on the complexity, honestly. So, like for some people, it depends what you own. Sometimes a will might be more than enough. But if you have multiple assets, you might want to trust, especially if there's a business involved, because I'm seeing a lot of times where business owners pass away and they want, if the business in a trust, they can kind of dictate who's going to do what. So it really depends on the person. But the minimum you should have is a will. I mean, I tell everyone the minimum you should have is a will. Whether or not you need a trust, it really comes down to a case by case scenario. I don't want to tell everyone, hey, go out and get a trust, because you might not need one. But the minimum you should have is a will, especially if you have assets over $50,000.
Yes. Another quick question is that what does the excuse me, the trust prevent does the trust protect the the beneficiary in case you know from the government getting a lot of whatever you leave to that beneficiary? In other words, these are
Taxes?
advantage.
Like, are you
You
asking
like
it?
taxes?
Yeah,
Yeah,
and
so yeah,
and
certain trusts, not all trusts. Like I was saying
mhm,
before, that marital trust. So the way the marital trust works is when the first spouse passes away, it passes all the assets to the second spouse, but it's tax deferred. They pay no taxes. Now, when
okay,
that spouse passes away, and then those assets are passed to the children, then the taxes can kick in. So depending on the situation, there are certain tax benefits. That's why a lot of people, create trusts, especially when you start getting into the $1 million range stuff. You definitely want it, but it depends, like I said, on a case by case scenario. And there's lots of different types of trust that you can set up. I mean, that's why you heard people that, like I said, that term trust fund babies. Like a lot of grandparents set up trusts for their grandkids, where they can give the money to the kids, a certain amount year per year. Because if you give too much money in one time in within the tax year, you can hit certain tax brackets. So what they'll do is they'll take the lump sum and they'll spread it out into yearly payments where they don't hit certain tax brackets. So there's different ways of doing it. But this is why you really want to sit down with an attorney, especially if you have assets, and really get a good snapshot of what you own and what you're trying to do, because this is estate planning. You know what I mean? Because you also have to think in terms like this. You might not think your house or your assets are worth a lot now, but in 10, 15 years, your assets are going to be worth a lot more money. So that's why it's a good idea to start doing this now and have an idea, and minimum do your will. And then as far as the trust, you can do that later on if you really have to, if it makes sense. But this is why you want to do that, because a lot of people own assets. And especially I know people in Brooklyn, they bought their houses for like $100,000, 30 years ago. Now they're going, Kenny, my house is worth 1.6 million. Am I going to get hit with the capital gains tax? I'm like, yes, you are. You know what I mean? So this is why it's good to plan this stuff now, because I see, especially in a lot of the neighborhoods that I'm working in now, a lot of people's assets went up a lot and they want to pass it over to their kids. And I didn't do the New York estate tax cliff, but if you go like $1, or I believe it's $7,500,000, like it kicks in and you have to pay federal estate taxes and New York state taxes. So it's quite a bit. So this is why, it's important to get all this information now and prepare for the future.
Okay, but
yes,
Ken, we ain't in the $7 million. I mean, if you are, then I need to send you some information for my events I got coming up. But for us who we just want to make sure that our final arrangements are taken care of, what do you think is best for us?
What's best is a will. Minimum start with a will. If you have a property, then it might make sense to eventually have a trust. The reason why I say that, if the property's under your name and God forbid you get sued, if someone trips on your side, I mean, things happen. You don't necessarily want that property at risk. Usually the rule of thumb is we say anything over 500 grand, definitely get a trust. But minimum you should have is a will, because you want to dictate how your final assets can be distributed. Go ahead, Hanzel, what were you going to say?
No, I was gonna say, yeah, you should always have a will. And think of a trust as a separate person, right? If you have a property, right, and you put the property under the trust, no one could go after, if you got in, God forbid, into a car accident and they want to sue you personally, they can't go after the property because it's under a trust. It's like a separate person. So that's what Kenny's referring to as, if you have a piece of property, you want to put it in a trust, that way it's protected and nobody could come after it in the event that they sue you personally.
You see, just another quick question. I'm thinking about generational wealth, to transfer generational wealth. So, is the trust would be the better way of doing
If
that,
you're
right?
trying to transfer wealth, yeah, if you have a certain sizable amount, or you see that it's going to continue growing, then yeah, you're probably going to want to do a trust. But what I would do, I would love to, talk to you. I have my Instagram and stuff, and we can really sit down and go over, what you have, and build out a personalized plan for you. Okay, Maurice?
Thank you.
No problem, man.
We are
Someone
at
asked how long is a, oh,
No, go ahead.
someone asked how long is a will good for?
Oh, it's forever. I mean, until you die. It's just like I said, don't remove those staples. If you prepare a will, don't remove the staples.
And don't laminate it, right?
Yeah, don't do any of that stuff. You can the if the court sees it when you submit the will, they're gonna think that the person who had the will created wanted it destroyed or something like that, and that's the reason why they removed the staples, or pages are missing or whatever, or they laminated it. You don't do anything to the will once it's created.
Let's keep it safe.
Yes, put it in a safe place, and just keep it there.
What good would it be to have it on a computer? Because you said it has to be notarized, but if you, God forbid, there's a fire and everything goes.
If there's a fire and the will's destroyed, then the will's destroyed. You keeping it on a computer, it somebody is, if like we said before, somebody who wanted to contest it, they're gonna say, well, that's not valid. It's on a computer, right? The only way, well, I shouldn't say the only way, but because people still contest it, but with you having the will stapled and submitted just as it is, it's harder for somebody to contest it that way, right? It's hard for me to say, hey, the person who passed away, the deceased, um, wanted this will destroyed, but then why didn't they pull out the staples? Why didn't they get rid of it? Why is it still there and they're safe? You know what I mean?
Got it. And we're talking about end of life, but also I would love for everyone to be mindful that things happen. I know Kenny had mentioned it. Things happen when we're alive, where we are in a place where we cannot make decisions for ourselves. And so we still need health proxies, that people who can make decisions about your health when you can't. You need to have your life insurance also.
Yeah.
All the things that, can help us when things go wrong.
So when and I got this done personally, when I got my will created, a friend of mine who did the will for me, he did it all together as a package. Health proxy, power of attorney, will, he did it all together as one big package. So if you are planning on doing a will, I would recommend, getting all three done at the same time, the health proxy, the power of attorney, and then that way you have everything included in that one package.
Any other questions?
Yes, I have a
Yes.
question.
I have a quick, oh,
Okay, so we'll do these last two. It's Tiara and Marilyn.
Yes. How far down do they look for your family members? Like if your beneficiary and everybody done died, like your immediate people that you listed, how far down will they continue to look? Do they go into like after the parents, your children, cousins, aunts? How far down would they look before the state takes it?
Oof. I mean, I think they try, but I don't know how far down the line they go. I think they and they go until they can't find somebody,
I mean, because anybody
yeah,
could come out and say, "Oh, I'm a cousin." Like, how do they go about proving?
yeah,
Because they ain't
yeah.
gonna have the same last name. I mean, how would they know?
I mean, even I've seen them go to even cousins, but second cousins, I'm not sure if they go that far. Um, yeah, that's an interesting one. That one I might have to look up. That might be like a case study on that one.
I'm a call.
How far down the line they go.
Okay.
Yeah.
Okay, Marilyn.
Yes, that was me. That was my question. The next
Oh,
person.
that wasn't Tiara.
Oh,
Oh, I
Tiara.
have one question.
Okay, go ahead.
So I had my will done, and the attorney advised me. I thought, like, if anything happens to me, I'm not gonna be here. I'm probably not gonna need the will. So should I give it to my dad, who would be my beneficiary? And they told me no, that it needs to be in my possession. Do you guys agree with that?
I would agree with that. I would
Okay,
keep it in a safe spot, and instead of giving it to your dad, you keep it with you in a safe spot, but maybe letting your dad know where the will is.
that's what they said. Yeah.
Yeah, that's what I would recommend. I
Is
Okay.
your
wouldn't.
dad also the
Yeah,
executor on the will?
Yes, the
Yeah, so he
beneficiary and
needs to know
executor.
yeah,
where it is, but I wouldn't necessarily give it to him.
yeah,
Okay.
exactly.
All
Yeah.
right. Thank you.
You cannot save your will on a computer. It's not helpful there because it has to be notarized and like a wet signatures and stuff. So
Yeah, yeah.
it has to be a real live
It's
document.
it's so important. I mean, think about it.
Two
So it's
witnesses.
yeah, two
Two.
witnesses. Yes. hmm the authenticity of it is so important. So you gotta keep it as is.
Well, I want to say thank you again to Hanzel and to Kenny for this information. Thank you to Team Jackson for putting it all together. I know that my team would like to share anything upcoming.
Yes. Thank you everyone for coming. Thank you, Kenneth and Hanzel, for hosting our webinar this evening. For everyone's awareness, we do have a health fair coming up November 1st. So please be sure to RSVP, share it with everyone that you know. We're gonna have a lot of resources there. So come join us, and yeah, thank you.
Also, I see that there was a request for us to do more in-depth information around people with disability and children. And so we'll take everything into account. If there's any types of workshops or information you guys think that we should be giving out to the public, feel free to let my team know. This webinar will be available on my YouTube channel, Assembly Member Chantel Jackson. And if you you all will receive an email with the link. So that's that.
Thank you, everyone.
Thank you all for coming. You can stop recording.
Thank you. Have a good night, everyone.
You too.
What time is the health fair and where is it?
It's 12 p.m. to 3 p.m. at Melrose Classic Center, 286 East 156th Street.
All right. Good night, everyone.
Good night, guys. Thank you
Good
so much,
night.
ladies, for having me.
Yes,
Good night.
course.
Thank you.
the information was
Good night. Thank you.